VNRC. I appreciate everybody taking the time today. Jon Groveman's our Policy and Water Program Director. And as we discussed last week when we gave an overview of the history of Act 250 and some of the changes over the years that have been made and outlined what we consider to be the need to modernize the important law, today we're going to move beyond that history and talk about what the future may hold for it, what legislation has passed out of the House of Representatives this year and is pending in the Vermont Senate. So we're going to talk about some of the reasons that we're supporting changes to Act 250, give a very brief background about the Commission on the Future of Act 250 that was formed by the Legislature nearly about 3.5 years ago, the work that they did, and then more recently the effort by the House Committee on Natural Resources, Fish and Wildlife to modernize Act 250 and the bill that they passed out of the House just before town meetings. And then just talk about some of the changes, how it relates to our current circumstances with the COVID-19 crisis. And hopefully we're going to get through that in short order in order to give folks an opportunity to ask questions or make comments. I did note last week, I recognized a lot of names. There were some practitioners who were pretty familiar with Act 250. It looks like today there's maybe a greater number of folks who have some background there. So hopefully we can have some discussion about what the future might hold. That'll be interesting to everybody. So as we noted last week, that we feel as though Act 250 has been really critical in protecting not only Vermont's character, but its natural resources, and I think arguably its economy. Oftentimes folks will criticize Act 250 as being a drag on the economy, as making it too expensive to develop. There's been studies over the years, including a study by an MIT professor in the mid-90s that looked at Vermont relative to other northeastern states, and that he concluded that Act 250 has been a positive economic factor on the state in that it helped stabilize our financial institutions. While it prevented the state perhaps from booming as high during economic boom periods as other states, it didn't crash nearly as low as other states did. And we saw that in the housing crisis about 10 years ago. Around that same time, VNRC did a bunch of work to look at job creation, wage increase, in housing development and housing affordability, and found that Vermont fared really fairly well, if not ahead of most northeastern states, including during some of the decades since Act 250 was passed, New Hampshire. It's also had a pretty critical role in protecting some key natural resources. John, you wanted to comment on that?
Yeah, I mean, this goes back to what we talked about last time about especially the environmental board's role in shaping Act 250, but there's some really important decisions about water quality, looking at large projects and the hydrologic impact of a project on rivers and streams, and not just individual Agency of Natural Resources permitting. There's some really interesting and important cases around wildlife habitat in the 80s, around deer wintering areas, a case called Southview from the southern part of the state, and Parker's Gore, which is a bear habitat case involving Killington ski area. And really, without Act 250, the broader water quality issues and wildlife habitat, like deer wintering areas and bear habitat, would not be protected.
So as we said last year, though, it has aged relatively well, but it's showing its age after 50 years. There were some early success stories, Waterbury Shopping Center, the St. Albans Walmart, that dealt with sprawl more effectively than the Act has in recent years, especially since the administrative processes were changed in 2004. There's other gaps in the criteria that don't deal with some of the emerging environmental challenges that we're facing, like climate change. That we're increasingly aware of the important role that large blocks of forest and the connectivity between forest blocks serve for wildlife habitat. and for climate change. And there's not criteria or really the jurisdictional triggers that are addressing those issues. So those are shortcomings in Act 250. There's also been a lot of changes over the years that have usually not been good. They're piecemeal changes, exemptions for various types of activities. That's weakened the law. And then most significantly, with the last time Act 250 was really changed in a dramatic way was in 2004, where the administrative and appeals process were changed, and that has set the law back significantly, in our opinion. So, and then just other changes that are worth pointing out, that when Act 250 was passed, the state had just passed a modern regional and municipal planning law that hadn't really been implemented. Many communities, especially rural communities in the state, didn't have any zoning in effect. We didn't have active regional planning statewide. We didn't have some of the federal legislation like the Clean Water Act and the Clean Air Act that changed significantly how the Agency of Natural Resources regulates development. And then just science has changed. Our understanding of things like river corridors and stormwater, non-point solution have all changed over the past 50 years. So there's an opportunity in updating the law to bring it into conformance with kind of modern science and our understanding of things. And the legislature recognized that. In 2017, under the leadership of David Dean, who was then the chair of the House Natural Resources Committee, the House passed legislation and the Senate agreed to form a study committee to look at Act 250 and to determine ways that it should be improved to make it continue to play an important role in the state over the next 50 years. There were 6 members of that commission, 3 House members, Representative Amy Sheldon from Middlebury, Paul LaFave from the Northeast Kingdom, and David Dean, who has since retired from the State House, and 3 senators, Chris Pearson from Chittenden County, Brian Campion from Bennington County, and Kurt McCormick from Windsor County. They were the commission, and then there was an advisory committee made up of a lot of different folks from environmental background. VNRC had a seat there, from the planning community, from the development community, from the academic kind of natural resources community, and they provided a lot of information and testimony to the commission. The commission also held, I think it was 6 pretty well attended public hearings around the state. They did other research. Legislative Council worked with them to kind of do research and understand opportunities for modernizing Act 250. And they issued a pretty substantial report. This is the link to it. I'll give you a minute if you want to write it down. I'll have to warn you, the actual report with all of the addendum and appendices to it was about 6 inches thick, but it had a pretty comprehensive set of recommendations, including improving the planning provisions of Act 250. As we talked about last week, you'll recall that Act 250 was intended to have 2 pieces to it, a capability and development plan, which still exists but doesn't play an active role. That's kind of a development sensitivity plan showing the areas that are adequate for development and might be best avoided. And also it was intended to have a land use plan. The report had specific criteria for a range of criteria update, including climate change criteria, updating to the water quality criteria, the traffic criteria. It proposed better dealing with equity and environmental justice in Act 250, which is a growing concern in the state and is certainly a growing concern at VNRC. And it included better protection for those forest blocks that I just mentioned. Other recommendations included changing some jurisdictional triggers. The commission had recommended exempting certain development in certain designated areas, and we talked about those designations last week, designated downtowns and neighborhood development areas. The commission recommended removing some of the exemptions that had put in place for forestry and agriculture. It recommended that jurisdiction be imposed on development around interstate interchanges. It also significantly said that we should bring back some version of the environmental board that was eliminated in 2004. Not necessarily a 9-member citizen board. I believe the commission recommended it be a professional board, but that was a key recommendation of the commission. So the report was submitted to the House Natural Resources Committee in 2019, early in the legislative session. The committee worked throughout that year on a bill. VNRC supported the recommendations of the commission. We provided a lot of input to the commission, and I think we were pleased that their recommendations were pretty consistent with many of our positions. However, it was pretty obvious that it did not have necessarily the broad support that would be required to not only get it passed out of both bodies, but more importantly, get signed into law by the Scott administration, by Governor Scott. So there was concern that the commission, some of their recommendations were not going to see the level of support necessary to become law, and the committee struggled with that for most of 2019. And then I'm gonna turn it over to John to talk about kind of going forward, what's happened more recently, and what the bill that was passed out of the House looks like.
Okay, thanks, Brian. So I'm going to tell the story of how the bill moved through the House over the last 2 years, and then we'll talk about where the bill is today. So I thought that the most efficient way to talk about this was the way VNRC thought about the different parts of the bill. They fall into 3 categories: process, criteria, and jurisdiction. So I'm going to talk about some of the key changes in those areas and where the House landed on those. I want to note that I'm going to try to hit on as many things as possible, but there's just too much in the bill. It's a 60-page detailed bill. So if I miss something and you have questions about it, please let me know. But we just don't have time to go through, deep line by line, like every change. But I'll try to hit what we think are the high points. So next slide, Brian, if you could just hit the slide. So process. So as Brian talked about, the commission on the Act 250, the next 50 years, recommended bringing back a version of the environmental board. That was controversial, didn't have a lot of support. VNRC, going into this legislative session, after working with the administration and talking to a lot of other stakeholders, we supported altering the Act 250 process by having major Act 250 applications heard by a hybrid of the district commissions and a professional state board, with appeals going to directly to the Vermont Supreme Court. So it basically would remove the environmental court from that process. It would take a whole webinar to go through all the reasons for, why we thought that made sense. Some of the highlights were that we believe that it made sense to give the commissions more resources and ability to deal with the complicated issues of Act 250, and having a hybrid of district commissioners and administrative board would bring us closer to the environmental board that we had before it was eliminated in 2004, which, as we talked about last time, we felt getting rid of that has really sort of harmed the administration and the precedent that has been set in Act 250 to kind of guide these decisions on these major projects. This was probably the most controversial provision of the bill that was discussed this year, and the bill that passed the House did not include significant changes to the process. I would just note that we still think that work needs to be done to address the real concerns about how appeals are heard in Act 250, how Act 250 is administered, and the support that district commissions need to be able to make complicated decisions on complicated Act 250 applications. There is one process provision that did remain that was significant, having to do with the House bill requires a pre-application scoping process. So 30 days before you could officially begin the Act 250 process, you'd have to provide notice of an application to the district, to the municipalities and regional planning commissions and adjoining landowners and the district coordinator and there could be a pre-application hearing, really a public meeting, not a hearing, just to informally discuss issues and maybe resolve issues before you formally start the process. So that is in the House bill. So in terms of the criteria, going into 2020, looking at other stakeholders and their positions and trying to work towards a bill that could become law. VNRC supported updating floodway criteria to meet modern scientific standards, as Brian noted. Create an A&R river corridor permitting program. Right now, A&R does not issue a permit for development in river corridors, and so we supported creating that type of program outside of Act 250, while having the flood criteria in Act 250 updated to the modern scientific standards, add criteria to better address climate change, address impacts to vulnerable communities as really equity issues in terms of environmental justice, and address impacts to forest blocks and connecting habitat. So these changes largely tracked what was in the Commission's report. There are differences in how the report dealt with those or proposed to deal with those, but the House bill deals with all of those issues. And if people have questions, I would say, if you want to know what the environmental justice provision says, I'm happy to talk about that. If you want to know what the bill says about climate, it does add a criteria on climate adaptation. We could talk about that. But the point is all of those issues are in the bill. And I would note that there was one issue that we didn't, VNRC did not, we didn't oppose this, but it wasn't our proposal. There is a change to the criteria for regulating quote unquote forest operations. There's a definition for forest operations in the House bill. And basically it limits when hours of operations at these facilities could be conditioned and be curtailed due to the need for these facilities to operate during certain times of the year. So VNRC ended up supporting that provision as part of this package of changes, and that is in the House bill. And then the last category is jurisdiction. So going into 2020, VNRC supported expanding jurisdiction to address development in forest blocks, sensitive ecological areas. So this was really controversial. If you remember, Brian talked about the Commission on the future of Act 250 had proposed a tiered approach to jurisdiction, and that basically meant they were saying exempt certain development in designated areas, but then expand jurisdiction outside of those areas, with areas right outside those areas having narrow triggers for jurisdiction, and then as you get further and further away from these designated areas, you would have broader triggers and more Act 250 jurisdiction. And that was a really controversial part of the bill last year. And so we worked with a lot of stakeholders on, well, what could we do to expand jurisdiction while we're contracting jurisdiction in some of these designated areas? And we settled on, and the House settled on, revising what is known as the road rule, and then lowering the elevation trigger for development in Act 250 from 2,500 feet, which it is now, to 2,000 feet for all development except for forestry and farming activities.
Although, John, I apologize, there's a mistake here. That actually did not pass out of the House.
Oh, that's right. It got taken out on the floor.
That's right. There's a floor amendment that went back. Some of the legislators realized, I think some of the Bennington County towns in the Green Mountain National Forest had a pretty high average elevation. And when I think the larger assembly realized that the amount of jurisdiction that would be applied to some existing development, they decided to go back to the 2,500 feet. The road rule, though, is a really critical jurisdictional trigger in the bill, in that, as we mentioned, that was eliminated in 2004. It was widely seen as problematic in that what triggered Act 250 then, and we talked about this last week, was any road longer than 800 feet. But 3 roads that were all 790 feet did not trigger Act 250. So what the revised version is it looks at both roads and driveways cumulatively at 2,500 feet of cumulative road and driveway construction. And the intent is, if you're going to be encroaching into a natural area, into a forest block, into agricultural lands, that that we feel as though, and the committee felt as though, there should be some trigger to pull those projects into Act 250, because even though it might only be a handful of houses, the length of roads and driveways can have a significant impact on water quality, wildlife habitat, and other natural resources. So, and then going back to the commission had actually proposed 1,500-foot elevation to drop it down to, but as we discovered in the House, even 2,000 feet went too far for a majority of the House members.
Yeah, so I want to pause on this for 1 second, because I think it's really important, and this was really kind of the nub of a lot of the controversy around the bill, and it shows how difficult it is to grapple with changing these jurisdictional thresholds. And so the elevation threshold, and I apologize for that mistake, but it was in until the very end, right on the floor when it got pulled out. But we really, it was very difficult to find a balance between, where do we want to apply Act 250? What we said last time was, when Act 250 jurisdiction was created, it really wasn't based on where sensitive natural resources are, where we want our development. It's based on the size of projects. It certainly is structured in a way to encourage towns to have zoning and subdivision regulations, because if you have zoning and subdivision regulations, then the Act 250 thresholds for jurisdiction increase. But it's been really a challenge to kind of find what changes we could make to get support and have enacted into law to really start having Act 250 apply, so we're protecting resources that we want. And if the House bill were to pass just the way it is today, it would be a good step forward. But this conversation, I don't think, would end, because I think we're going to continually have to work on the planning aspects of Act 250 and trying to tailor it more, specifically to where we want to have Act 250 apply and protect, natural resources and Vermont values. So that's where the House landed. And Brian, do you want to say a little bit, because it's also been controversial, about the designated downtown? So we proposed, and the bill that passed the House committee exempted Act 250 in designated downtowns and neighborhood development areas. And then it was changed on the floor to add enhanced village designations. But do you want to talk a little bit about the rationale behind that?
Yeah, and we talked about this last week. There are several designation programs. What that means is a municipality can bring a map of an area, of a historic downtown, of a historic village center, of a neighborhood development area, which is an area that is designed within walking distance of a village center or downtown, and designed to avoid certain natural features. And there are different ways that jurisdiction is treated in all of those different ways. And it depends on the kind of development. Some large-scale developments are exempt. For example, folks might be familiar with the Burlington Town Center redevelopment, the old mall. That was exempted from Act 250. So there were a lot of different rules, and there was, I guess, a compromise made between a lot of different stakeholders who felt like, okay, these areas are very narrowly defined. They're heavily impacted by past development practices. They have an environmental screen to them through the designation process. And it was agreed with the different stakeholders discussing this position that there should be an appeal process that doesn't exist currently for those designations if they're going to be part of some effort to be exempted from Act 250, and that would be acceptable, balanced with expanding jurisdiction through the road rule and through the interchange rule in the countryside. And as we talked about last week, most of the residential development that's fragmenting our natural areas and our forests and our wildlife habitat is not subject to Act 250 review. So capturing more of that and applying new criteria to it, to us, was a reasonable trade-off to kind of standardizing the exemption in these different areas that are relatively narrowly defined and now would be held accountable. We did not support the village center exemption. because Village Centers is not as high a bar for designation as other areas. That was the House decided to amend the bill on the floor to do that. There was a concern from some of the rural caucus members that the bill wasn't providing the same kind of uh, easier pathway for redevelopment in the smaller village centers as it was in the downtowns. So it was agreed that the enhanced village centers, which means those village centers that have a town plan in effect, zoning bylaws in effect, subdivision regulations in effect, would also be subject to that exemption. Still an area of concern to ours. It's not a huge deal because it's not a whole lot of land, and most of those areas are fairly tightly defined around the commercial centers in historic villages. But that was seen as a necessary compromise to pass the bill with as large a majority as it got. And then I mentioned interchange areas. There's also a changes in the bill to deal with how jurisdiction over recreational trails are dealt with. And John, you want to explain that?
Yeah. So, and before I do, I just want to say one more thing about if there are questions, about, we've heard questions about the exemptions in the designated downtowns and neighborhood development areas, and concerns about floodway and river corridors development. So if people have questions about that, please note them in the chat. And I would just briefly say that we felt that having A&R create a river corridor program where they'll be actually permitting development. Initially, any development that would have gone through Act 250 would be permitted by A&R, and then by 2023, A&R would actually expand that program to cover river corridors for projects that wouldn't currently trigger Act 250. So I think that was part of the trade-off we sought. But if people have questions about that, please let me know, because that's something that I've heard about as the bill was moving through. So trails, importantly, this has been another issue that has gotten a lot of attention. And even before the COVID crisis, there's been a strong desire to promote the recreational trails in Vermont as an economic development resource. And VNRC certainly supports trails and the use of trails, and see it as a great way to get people out into the environment, and can see it as a way to be important part of our economy. But we also see that trail building has environmental impacts, and the density of trail building has increased significantly over the last 5 to 10 years. And Act 250 is the main tool to regulate trails, and there have been concerns from trail developers about how Act 250 has been applied to trails and when it's applied to trails. And so VNRC worked with other environmental groups and leaders in the trail community to come up with a proposal that is in the House bill that would basically work to take trails out of Act 250 regulation and create an A&R program to regulate trails. It gives A&R 2 years basically to set up this program. And while that program is being set up, there were some changes made to the Act 250 and how it applies to trails. It basically confirms that if a trail is in the Vermont Trail System, that it's 10 acres of disturbance that is the trigger for Act 250, that the disturbance, really the calculation of acreage is based on the actual disturbance, so not the amount of land the trail is on. And it does not look at whether that trail connects to other networks of trails. And those have been a few of the issues of controversy and some confusion over the last few years in terms of trails in Act 250. And so for this 2-year period, while A&R is developing a program that will need to be approved by the legislature, those provisions are in place, but they will sunset in 2022, according to the House bill. And so if A&R doesn't come up with an alternative, we'll go back to the Act 250 regulation of trails as it exists today. So that is a provision to watch, and I think something that will be discussed as we talk about measures to deal with COVID-19 crisis and how we come out of this as a state and move forward in terms of what types of economic development are people going to want to see. So next slide. So then importantly, there's a bunch of studies in the House bill that I just want to note, and rulemakings. And so this is the House passed bill. Obviously, the bill is only halfway there, and that'll be the next slide, which is kind of where we're going to go from here. But if the bill passed, it would be a study on the impacts on racial equity and diversity in Act 250, basically whether or not Act 250 is being applied fairly to communities that have been historically been discriminated against, whether or not Act 250 is dealing with environmental justice and has dealt with environmental justice issues adequately enough. And it involves the Executive Director of Racial Equity and the Human Rights Commission in Vermont. So that is part of the bill. There's a really, what I think is an important study on planning. So another issue that was more controversial than you would think was updating the planning provisions in Act 250, basically updating the capability and development plan that Brian mentioned earlier and applying it to projects now. There was a lot of questions about, well, what would that mean for applicants and projects? How would it be applied? So there's a planning study to look at all of those issues. There are rulemakings related to the A&R program to regulate river corridors. There's a rulemaking provision related to the new forest block criteria and connecting habitat criteria that's being added. Fish and Wildlife would basically adopt a rule that would set forth how impacts would be evaluated and avoided, minimized, and mitigated under those criteria. So if this bill were to move forward, there would be a lot of work to do, even within the framework of the bill, to bring some of those provisions to light. So next slide. So Brian, you want to tackle this one?
There's a little bit of a, we don't know what the future holds for this bill, because we share the legislators' priority. They have a crisis. They need to deal with the immediate needs of Vermont and of the state budget. However, we also think we are going to emerge from this crisis, and Act 250 is going to continue to play, if not as important a role as in the past, probably a more significant role. I do a column in the Times-Argus-Rutland Herald I share with about 6 or 7 other people called The Weekly Planet. Last week, I noted that even though we're sheltering in place, I live in the Mad River Valley, you drive around town and it looks like a ski weekend, the number of out-of-state places. And I've talked to some realtors, and there's been an uptick in interest in long-term rentals and housing purchases. A lot of people never went home from this when the ski areas closed. And I think that's an indication of Vermont's kind of potential role as a safe haven for a lot of people. And we're going to see migratory changes. We're seeing them globally. I think we're going to see them within the United States. And I think growth management and land use regulation and land use planning and natural resource conservation as part of a development review process is going to be as important, if not more important than ever moving forward, especially as we're dealing with threats to our forest blocks, the connectivity of wildlife, and other things that aren't well regulated today. So we are not being tone deaf when we talk about the need to update Act 250 at the same time that we're dealing with this larger crisis that hopefully will emerge from intact and stronger than ever. So we are continuing to work with other stakeholders, allies in the legislature and now in the Senate at the appropriate time to update the law, because we think that the reasons that the Commission on Act 250 were formed in 2017 are still as valid and relevant today as they were then. So that said, we don't know where things are going. There's a lot of rumor. Our understanding is the budget crisis is the priority of the legislature, appropriately so, but that there's going to be not one bill to address it, but several bills as their understanding of their revenue shortfalls and federal aid evolves over the course of the summer. What we're hearing is the legislature will stay in session through the summer into the early fall with the hopes of taking final action on a long-term budget for next fiscal year at that time. And we're also hearing, and this is, kind of secondhand rumor, but it's from pretty well-informed folks, that there will likely be a window in the summer where the committees will deal with policy that are unrelated to the COVID-19 crisis. And that's our hope. We hope that they have an opportunity to take care of some of the unfinished business that that was kind of put on the back burner town meeting week. And if that can result in a bill being passed out of the Senate, we'll welcome that. We're also hearing there is a likelihood it could be a scaled down version. It was a big lift for the House Natural Resources Committee. There's not going to be the amount of time that a bill of this scale and scope typically requires for a committee to deal with in terms of hearing testimony from all of the interested parties and stakeholders. So there's a very real possibility that some of the key provisions of it, dealing with jurisdiction and criteria perhaps, will be what the Senate's able to pass out. That's all conjecture on our part. As they move beyond COVID-19 and fiscal crisis, we're hoping, like many of the folks on this call, will learn more and have a better idea of what the future might hold. But we still think that we're more than halfway there, and we hope that we can make some improvements this year. John, do you have anything to?
Yeah, no, I mean, I think that's really well said. I just think that these issues aren't going to go away. I see both sides of the issue of, we're in this crisis. How do we move forward in a way that, the public can weigh in on these proposals, and hopefully over the next month or so, the legislature will, find a way to do business and involve the public in a meaningful way. But, there are, issues with Act 250 that we discussed today and last week that if they're not addressed now, we're going to have to deal with them. We would have had to deal with them if we didn't have the COVID-19 crisis. And I think it's just going to become, more necessary to look at, the laws we have that shape how Vermont grows, going forward. So, it's going to be a tricky dance, we'll see. I saw one question about, the Senate is not posting, Senate Natural Resources Committee is not posting a lot on their calendar. And I think it's because what Brian noted, that, right now they're kind of in a holding pattern where the legislature is really focused on the immediate needs of Vermonters. But I think that'll change if they make the turn to policy issues that Brian noted. And if people want to see some action on any part of what's in the House bill, we're kind of going over some of the highlights here. The other part of the question was, should people contact the legislature or the Senate and say, you should address these issues if you can find the time and a way to do it? Then yeah, I think you should contact your senators and let them know what you think about that. Either way, and we're certainly doing that. We're in contact with them, and we're trying to find out what's possible, what we can do that's responsible. But individuals should do that as well.
So we tried to keep it pretty quick to make room for any questions or conversation. Stephanie, I'm going to stop the screen sharing to look at the chats to see if there's any questions. There seems to be a handful of them.
Great. Yeah, I thought since there were two about forest blocks, maybe we could start there. So we have a question from Cree. Are forest blocks defined by a delineated conservation district or wildlife corridor? We have a question from Bill. How would the House bill address forest block preservation? And we have a question from Paula. Forest block regulations are up in the South Burlington Planning Commission. Should the Planning Commission be considering state level regulation?
So John, you want to explain the criteria changes?
Yeah. So the bill does have a definition of forest block. It is not based on a delineated conservation district. It does, and there's also a definition of connecting habitat, which I think is analogous to a definition of a wildlife corridor. But forest block is defined in the bill as a contiguous area of forest in any stage of succession and not currently developed for non-forest use. The forest block, and then it says that it could include certain features. So basically, it's a very broad definition, and the rulemaking that I noted earlier that is part of this bill, I think that's where the Agency of Natural Resources rule would much more specifically indicate what they would look at in terms of a significant forest block that they think should be addressed in Act 250. There's also a definition of fragmentation in the bill, and connecting habitat is a very broad definition referring to land or water or both that links habitat within the landscape. So these are very broad definitions, which we think is a good thing, that they're pretty broad, but we really have to watch the agency rulemaking to see how the agency proposes to narrow those definitions. So
it's worth adding that the agency has done a significant amount of work in mapping natural resources, including forest block and connectivity areas over the years. So they have the foundation to create a strong rule, and we'll certainly be watchdogging that rule. The other way that the bill that passed out of the House deals with it is it's one thing to have a criteria. You can have all the criteria you want, but if you're not regulating any development and applying that criteria to development, it's not doing any good. And that updated, modernized road rule to get at some of the fragmenting road and driveway construction and land subdivision in the countryside and forest blocks is really the way that criteria will be applied. And that's why that's such an important balancing act with those designations, the exemptions and the designations.
Thanks.
go
ahead.
I was going to say, Brian, do you want to take the one about South Burlington and their planning effort?
I guess I'm not entirely sure I understand it. Towns and municipalities are doing more forest block planning and conservation because Act 171 was passed a couple of years ago, which amended the Chapter 117, the law that describes how towns should undertake their planning efforts. I think that what we have felt is that these forest blocks and the connectivity are regional issues and statewide issues. They're statewide resources. There's an appropriate role for the state to be overseeing development in them and regulating development in them. Some, as I said last week, some municipalities do a great job with land use planning and regulations. Others don't. And these are issues that transcend municipal boundaries. And like wildlife habitat, like water quality, there really are state resources that require state oversight.
I thought it would be great if you could talk next about the criteria for addressing climate change. That was Enrique's question.
So there's a few different ways that the House bill proposes to address climate change. And I guess I would note that you should contrast this to against the House bill last year was requiring that for any project, greenhouse gas emissions be calculated, and then an applicant would have to offset greenhouse gas emissions. And there was a lot of debate about, well, how do you calculate greenhouse gas emissions for a particular project? And over the course of the deliberations and the debate, the House committee came to 3 different ways to address climate. One is that, so criterion 1 of Act 250 right now is air and water pollution, and the bill separates air and water out and creates criterion 1 for air and then 2 for water. And then under air, it adds a greenhouse gas as a pollutant that may be addressed under Act 250. It doesn't say how to address it. It doesn't say that greenhouse gases need to be calculated or offset. but it clarifies that greenhouse gas is an air pollutant. I think that's a clarification because I think under existing law that you could argue that greenhouse gases falls under the air pollution criteria, but it's good to have that clarity. There is added to the capability and development plan a statement about the serious threat that climate change poses to human health, and that Vermont needs to take steps to minimize greenhouse gas emissions and address climate change. So this provision is really aspirational, but it could become more applicable to projects if the bill passed and that planning study went forward and the capability and development plan was readopted and there was a decision to apply that plan to specific projects. But so right now there's a more aspirational goal. And finally, there's a provision that was inspired by Peg Elmer, who I see is on the call, about climate adaptation. And I think and hope that Peg likes the way this came out. But basically, it says that it adds a criteria that says a permit will be granted when it is demonstrated that a project will employ building orientation, site and landscape design, and building design that are sufficient to enable the improvements to be sited and constructed in a way that it could adapt to the effects of climate change, and then it lists some of the effects of climate change. So the idea there is let's build things that won't get destroyed because of extreme weather events we're going to have as a result of climate. Also implicit in this criteria, I think, is let's site our buildings to take advantage of passive solar and site them smartly from an energy use and efficiency perspective. So those are the three main things that the bill does for climate.
Thanks, John. I thought we should address Judy's question next, if you're willing. And she asks, in a very short synopsis, could you explain the Act 250 process now and how you wanted to bring back the environmental board in the new bill?
You want me to take that, Brian?
Sure. Yeah, go ahead.
Well, I mean, I can't briefly explain the Act 250 process now. We kind of did that last time. Basically, there are 9 district commissions that hear applications, and they make a decision, and most of those are done without a hearing. And the ones that are done with a hearing, some of those are appealed and they go to the environmental court now, and then to the Vermont Supreme Court. And so, we supported the provision in the bill last year, the House bill, and in the commission report to bring back some version of an environmental board to replace the environmental court. But that just did not have broad enough support, as we noted. So we certainly are open to other ways to improve the process. We think that we do need to bring back some version of the environmental board to administer the program and really make decisions on appeals that will do what the environmental board did in the early days of Act 250, which is to really breathe life and explain these criteria and how they work, and be a citizen-friendly process. But right now, I just think we're at a junction where there's not agreement on how to do that. I would very much doubt in this time we're living in, dealing with COVID-19, that if the legislature picks up the House bill, that it would be able to, solve that particular issue. But I do think that it's all the issues with the process now that we see, that we went over last time, and you can look at our presentation from last time, they exist and they need to be addressed ultimately. But I don't know, Brian, what would you add to that?
No, I think you're right. I think as we discussed last week, it used to be kind of a vertical integration is how I describe it, where you had the board that oversees the district commission deciding on their appeals. Now you have a natural resources board who is tasked with representing the district commissions, but isn't a party to them. And so you have three entities that aren't as well coordinated as they were when Act 250 was first enacted, and the first, whatever it was, 35 years of its existence. So
Thanks. And I thought we could go next to Bill's question about trails. He says, would trail regulation by A&R apply to existing trails or just to propose new trails?
Well, I could take that one. So I think the goal is to set up an A&R program to regulate all trails. There's in the House bill, it's on page 59. You should read it. Section 14A. It basically saying that A&R needs to report back by next year, the end of this year. This is how it's written. I'm sure the timing will change, on basically creating a system of best management practices for trails that would apply to the Vermont Trails system trails, and the Vermont Trail System is defined in the bill. So I think the idea in the A&R report back is to say if a trail is part of the Vermont Trail System, then it would go through A&R and not through Act 250. The way that VNRC has talked about these issues with the trail groups that we worked with is that the goal is ultimately to have all trails. If this were to work, if we come up with a system that we think will regulate trails appropriately to the appropriate level, that it should really apply to all trails. We shouldn't have a bifurcated system. But that's not exactly what the report section of the bill says. But A&R, I think, has a wide discretion to basically make a recommendation to the legislature in terms of what it thinks should move forward in terms of trails. So I hope that answers the question.
Yeah, and I just want to chime in from a VNRC perspective. The goal isn't to prevent trail development. We are all trail users. I think it's more important than ever now, if at least for my own mental health, to get outside, get into the woods. The trail networks around the state are developing pretty quickly. There are potential environmental impacts. There's wildlife habitat impacts. There's water quality impacts. There's impacts on neighbors. And right now, because trail groups, I think understandably, are working around Act 250, that this is a way to have just best practices that they'll all understand and be able to build their trails to without a burdensome review process that deals with all of the criteria of Act 250. So our goal is that it'll really enhance trail planning and help the trail groups kind of be able to plan the trail with input from the technical folks at A&R, but not to prevent trail development in inappropriate locations across the state. And that's why it was important to have the trail organizations involved. And they're not they don't speak with a single voice. They have different interests depending on motorized or non-motorized, winter, year round. So it was really an effort. They did they really appreciate the time that they all spent in coming up with a compromise that everybody could live with. So we feel pretty good that this is going to be good for Vermont's recreational trail network moving forward.
There is also a question on whether the House bill is ready to go to the Senate.
It's already there. It was voted out of the House, I believe, on Friday before town meeting week, which is the week that the legislature takes a week off, and they have never gone back, only virtually. I guess they have gone back a couple of times, but so the bill is what they refer to on the wall of the Senate Natural Resources Committee. And if they take up policy, non-COVID related policy legislation, we're hopeful that will be one of the bills that they take up.
Great. Thanks. Also, if you're open to it, Brian and John, PEG has offered to clarify something about encouraging design that maximizes passive heating and cooling. If that's the case, I can unmute PEG.
Yeah, please.
Sure, I'm fine with that.
All right. Let me just find her so I can click the thing. All right. Okay.
Great. Thank you. And maybe Enrique Bueno as well, who raised the question about the climate and what is in the bill. There's this massive opportunity that we see in the bill that hasn't really been picked up on yet. that, let me see, I can do that too. We're, in terms of what Vermont contributes to climate issues, there's a pie chart that everyone sees of transportation being the largest. And certainly with COVID, we've seen what happens when the gas is just not being used by people and we're staying home. But the next largest piece of the pie is thermal. And since Active 50 reviews really large projects, we're trying to get language in 9F that would require that, not really, use the word encourage, whatever we can get through, encouraging design that will maximize passive heating and cooling, both on the site and in the building. There's so much we could save instead of trying to go back and doing after the fact energy conservation and mitigation on buildings if we did it right from the start. And Enrique has a fair amount of data on that and good arguments. And we presented it to the House side and we planned to submit it to the Senate side and are eager to do that, to just very simple language to make a big change.
Thanks, Peg. Yeah, there's a lot more work to be done on climate and energy efficiency, certainly. I just want to acknowledge Peg is a VNRC alum from the 90s, and glad you could join us today. Meaning she worked for VNRC.
Yeah, and I want to make sure I thank you. I mean, I'm very, very appreciative for everything that VNRC has done to push all the work on Act 250 and get it as far as it has. And it's so hard to have this at the edge and not be able to get it passed. So keep working.
Thank you.
Thank you. Well, it's 1 o'clock. We had said we'd keep it to an hour. I don't think there's any pressing unanswered questions. Are there, Stephanie?
I do think we got them all, and thank you all for weighing in. We will be sharing the video link in an email shortly after this.
Yeah, and we're going to continue these sessions. Next week, we're going to hear from our partner organization, Vermont Conservation Voters, who will be talking about mail-in elections, mail-in ballots for elections. They're going to be joined by someone, I believe, from the Oregon League of Conservation Voters. Oregon has a long history with direct mail voting, and they're going to talk about what their experience has been and how that might apply to Vermont going forward. So that's next week. Other topics coming up will be the status of our water quality implementation of our water quality laws, and most importantly, Act 64, the Clean Water Act. One idea that we're going to talk about is perhaps talking about climate migration, since that was an issue that we talked about today. So if anybody has any suggestions or topics that you'd like to hear about, you'd like to hear VNRC's position on, projects that we're working on, or any of our priorities, we'd love to hear from you and see if we can carve out some time on one of our Thursday noon chats to talk about it. So thanks everybody for coming, and have a great weekend.
Yeah, thanks everybody.